Grant you 3 minutes instead of 30 seconds.
Thank you, sir. Thank you for your generosity. I don't have any bombshells, but I do want to point out a couple of items. One is that the record does include a reference to the road width that was established by DelDOT at 20 feet. It's not 16 feet. I think that is evident from the record. But I want to call your attention again to these 99-9C considerations, which are prefaced with the phrase, in addition to other provisions, of course, which could result in the denial of an application. But in addition to other provisions contained in this article, the approval of a subdivision shall include consideration of the following. The Planning Commission said it, and Mr. Vincent said it, that the Planning Commission was not impressed with the developer's written submission on these issues. Well, these are responsibilities of the Planning Commission to consider these issues in the context of an approval. That's what the language in the code says. So you could imagine a beautifully, perfectly well-designed subdivision that was determined to be code compliant, but included or did not include a very thoughtful set of submissions regarding 99C. And would that subdivision be subject to denial for that reason? I think the answer is no, because the developer doesn't have, obviously the developer has a practical incentive to make a good submission with regard to 99C, but code compliance is established before that, not after. Code compliance is already determined. And then you have to look at the nature of these 99C considerations. Integration, minimal use, preservation, minimization of tree removal, screening of objectionable features. These are squishy standards. These are not standards that can be measured. Your shoulder.
I had not understood, but is squishy a term of art?
Yeah. Well, there are not precise measures that can. There are not precise considerations that can be measured. So, if the Planning Commission's desire was to deny a plan, it can say that inadequate preservation of open space and scenic views is a feature of this plan. How do we support that? How does a developer overcome a Planning Commission's conclusion that minimal use of wetlands and floodplains is not incorporated in this plan? What is minimal? How much tree removal is permitted? Tree removal is permitted. And to think that this is kind of a parade of horribles argument with respect to these tree removals. Why would somebody buy a wooded lot and then clear it? Not just a quarter-acre wooded lot, but an oversized wooded lot. Why would we expect that would happen? And the Planning Commission had the opportunity and was invited to impose conditions and didn't do it. The last thing I'll finish with is, again, this feasibility study. It's not intended to be performed on a lot-by-lot basis. It's performed on a tract of land. Test borings are done not just for particular lots, but all over the farm, that are all over the property. DNREC has said that the feasibility study is valid. That's in the record. That's in the September 3rd submission of DNREC. That's an email, I think. And it then becomes incumbent upon the engineer to design the finalization of the lots to take into consideration what those test borings reveal. So it's not lot by lot. And also, I think it is, it's my understanding, and I guess I could be corrected, that while there was a pause in the hearing process, it did allow for the submission of the subdivision plan upon which the feasibility study was performed. So I think that subdivision plan is in the record. If that's a bombshell, then I invite Mr. Robertson to correct me. Are there any questions for me?
You're saying the 2006 subdivision plan is part of the record?
No? Did I misunderstand that?
So we submitted supplemental information to confirm the solicits before.
Okay, all right, so I did mistake that, thank you. So what, instead of that subdivision plan being submitted, supplemental information was submitted regarding the soils from a soil scientist associated with the developer. So supplemental information was offered after that pause, which confirmed that the site was suitable for on-site septic in various locations. And then it becomes the obligation of the developer to cite those lots in accordance with the feasibility study.
Thank you, sir.
Just for the record, you made a comment a while ago about the statement made by Mr. Vincent. I didn't make any statements. Probably you meant Mr. Vince Robertson.
Yes, that's who I meant to be referring to.
Just for the record.
And I appreciate that clarification.
Thank you, sir.
And apologize. All right. Thanks again.
If I may, Your Honor, just since I had 4 minutes left, and I probably won't take a minute of it. So, Mr. Townsend talked about, woodlands and that sort of thing. But this goes back to my point about there wasn't a sufficient record for the commission to even consider. It's one thing if on a plan the applicant says, we are going to preserve these woods, and the commission says, well, we want to put a condition on that says you preserve either more or less of that, but you have a defined woodland area. This is my point. Here, we didn't know what we had. There was a woodland shown on the plan. There was the statement that wherever there was woodlands, there was wetlands. There's actually a statement on the wetland statement on the plan that says there's no wetlands on this site when we clearly know there's wetlands. And then we have the statement that on that plan that's just shown for informational purposes, that it may vary based on the individual owners, what they decide to do with it. Then there's also the statement in the record that a bunch of those woods may be cleared out because the soils are marginal and we may have to put septics in there. So it goes back to my point. The commission shouldn't be the one that designs a subdivision. With all those unknown variables, that's what the commission, frankly, was left with. We don't even know whether there was adequate preservation of woodlands because we don't know where those woodlands are really going to be based on the record. That's based on the transcript, based on the plan, based on those septic information. So, I just point out that's one example of what we were dealing with, we meaning the commission, when we heard this application. It was lack of a record, and when you apply that to those 99.9C criteria, you're left with the basis for the denial. So anyway.
So you're saying that it's incumbent on the applicant to take the squishiness out of the question by offering something concrete that the Planning and Zoning Commission can then respond to?
I think that's correct. We were left with too much squishiness and couldn't make a decision. I would put it that way.
Word of the day.
The word of the day.
I will take it back to Newcastle.
They do not teach you squishy in law school.
That is wetlands,
Explain that to them.
Well, that's true. Fair point. So, anyway, thank you.
Council